Hello, welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest today is Jeffrey Hare. And Jeffrey is an attorney in San Jose, California. He provides client-focused, outcome-oriented legal services to his clients. He's also a licensed real estate broker and real estate investor. Jeffrey specializes in real estate law, real estate property transactions, entity formation, commercial leases, loan documents, land use law, zoning and land use changes, municipal law, and key to our discussion today, mediation services. So he is a lecturer in law as a member of the adjunct faculty at Santa Clara University School of Law. I run into him time to time at events over there. He teaches negotiating for lawyers, and I take it alternative dispute resolution as well, correct? Yes. So Jeffrey also is on the mediation panel for the Santa Clara County Association of Realtors and the California Association of Realtors. Okay. And so today, related to all of that, we are going to be talking about settling legal disputes out of court, which is also known as alternative dispute resolution. Okay, Jeffrey, thank you for joining me today.
My pleasure. Good to be back.
Okay. So as we get started, I want to caution our viewers, one, that we're discussing issues in a complex area. So this is just a starting point for a bigger discussion. We want you to get qualified legal and tax advice. Also, Jeffrey is a California attorney. I'm a California CPA. I think the concepts that we have here are probably pretty well applicable, but some of the nuances will be different from state to state, and county to county even, I guess. So, so just be aware of that. All right, Jeffrey, this complex thing that we talk, alternative dispute resolution, some people call it ADR. Well, what are we talking about? Why do I need to know how it works?
Well, actually, it's pretty simple. Break it down this way. If you've got a dispute in your business or in a transaction that you've been involved in, you have three ways to resolve it. One is you can go and litigate, which proves to be very expensive and time-consuming. Then there are what we call the alternatives, and the two alternatives are mediation and arbitration. So those are the three ways that are done. The mediation and arbitration are considered alternative to the litigation process.
Okay, now these are the legal approaches, and some people, I guess they might take other approaches, but we won't get into that today.
That's right.
But I am a martial artist, folks, so. Okay, well anyway, yeah, and I rarely have collection problems, by the way. Well anyway, what are some recent developments in the judicial system that make alternative dispute resolution more important than ever?
Well, I think last time that we sat and talked about this, I had brought up the point that the court's budget has been slashed. The availability of courtrooms in the civil trial section are being limited and cut off and restricted simply because of budgetary cuts. Many courtrooms around the state have cut back on the hours, if not the days of operation. So it's taking longer and longer to get a matter processed through the court system. So seeking out a resolution through an alternative means, such as mediation or arbitration, is proven now to be even more viable than ever.
Right, or let's just say important, yeah, because otherwise you could be waiting for an awful long time, I guess is what we're saying, even to just get in front of a judge. So, and who wants to get in front of a judge anyway? I mean, it's so dicey once you get there.
Well, let me just add that the courts themselves have recognized for a while now, but even more so, that the benefits of dispute resolution process, they're now mandatory in the state and federal court system. When you show up in even a litigation context, you are going to go first and foremost to an alternative dispute resolution process of some type in the course of your litigation modes.
Okay, well.
It's an expensive way to get there.
Yeah, so I think, And so why delay? Why not try to get it taken care of before you ever get
That's
there?
right.
So why is litigation so expensive?
Mostly the cost, partly is the delays. Time is money.
Yeah.
The delays in getting something processed through a system that is set up and run by the state of California inherently is going to have bumps in the road that are just going to make it more expensive because of the delays. Also, in one of the most expensive parts of the process is what we call the discovery part of litigation. This is where you have to try and get all the records from the other side. And now that we're storing things electronically, it's sometimes very expensive to go and recover information from disks, from hard drives, from doing forensic analysis. And as the stakes go up, as the costs are greater, naturally you're going to have more lawyers involved. There's going to be more motions that are being brought. And it's part of the job of a lawyer to vigorously defend their client. So they're not just going to sit down and do nothing. So these delays caused by both procedural and scientific and technical problems are going to cause delays.
Yeah. So, but part of what we're saying is we may be getting other people aside from lawyers involved. We may have to have technical specialists,
experts, consultants,
forensic accountants, and forensic technicians, as far as computer scientists and so forth, in order to get into this stuff. It's kind of mind-bending. Whoever thought that we would get to this place when we started this whole tech thing?
Good example. Santa Clara County Superior Court just now decided there's so much what they call complex litigation that they have now divided and created 2 departments just to handle the complex department matters. So it gives you a sense of where things are going, that they've realized the need for having more specialization, and so they now have 2 judges assigned to hearing the complex litigation matters.
Wow, okay. So, I guess what we're saying, the next question in a sense is it mandatory or optional? These days what's happening is that you're telling me that the courts are just saying you will do this first.
Well, not only that, but I ask my students oftentimes, when they come in, I say, how many people here have signed a binding arbitration agreement? And I don't have any hands go up.
Oh, yeah.
And
anybody have a credit card?
And I said, how many of you have a credit card? How many of you have downloaded an app? How many of you have gone online and made a request online for some service? And all the hands go up. I said, then you have signed and a binding arbitration agreement. They are now built into virtually every single contract that anyone signs to do business today in the United States.
Wow. So, what's the difference between mediation and arbitration? I mean, now you're saying we're signing our lives away here. We've got this arbitration agreement. What's the difference?
Well, let me start by saying that arbitration started out, Federal Arbitration Act was enacted in 1925 and signed by Calvin Coolidge. So it's been around for a while.
Long time.
But even back then, it was viewed as a better alternative than going to court to litigate. But what's happened now is that it has become itself so complex and costly that it is, not that it's disfavored, it's just that it's often viewed as being as cumbersome as regular litigation. In arbitration, as in litigation, there is a decider, a judge that sits and makes a decision about the case. And so in binding arbitration, you either have a panel of 3 or so arbitrators or a single arbitrator who will issue a ruling based on the evidence presented. That's you're stuck with that. There is no recourse. There's virtually no appeal. Binding arbitration is final. That's one of the attractions for it. So now we focus a little bit on the alternative, and that is mediation. And it's the alternative to the alternative dispute resolution that is taking on more and more favor. The difference is in mediation, you go before a neutral party. The arbitrator is a neutral who makes the decision. In a mediation context, the mediator is a neutral who simply helps the parties to have a discussion about the dispute. And the parties are free to formulate a new contract, a new outcome. Let me give you an example of somebody who has entered into a contract to buy a property. Somewhere along the line, they've discovered something that neither side knew, and they realize that they have to make an adjustment. Well, if they go to court and fight over it, one side's going to walk away a winner, the other side's going to walk away with nothing. If they go to arbitration, the same outcome. If they go to mediation, they may decide, let's work this out. If the buyer still wants to buy the property and the seller still wants to sell it, they can throw out the old contract and formulate a brand new one if the parties agree. The role of the mediator is to help the parties see the creative outcomes they can reach if they're available, and they can formulate their own outcome and come up with a new contract. This is why mediation is so valuable. I like to say it's ABC. Mediation is affordable, it's beneficial, and it's confidential. And that makes it unique to the other forms.
So I've noticed that some people are actually fighting this binding arbitration thing, that they're saying, well, wait a minute, I didn't have a choice.
That's right. Did you know you signed that agreement,
Yeah, well, it says if I wanted to get the service or whatever, I had to sign this. It wasn't, something that I was given an option to, I didn't check a box.
I heard somewhere that the iPhone end-of-user agreement has 271 screenfuls of information that you would have to scroll through before you got to read it all and before you sign it. What do most people do? They click I accept and move on.
I'm not going to be here for a week looking at this thing while I'm making this decision.
And what happens is they find that the arbitration agreement will often have provisions in there, for example, that says that the arbitration not only is binding and final, but is to be held in the corporate offices of the company you're doing business with, and that could be in Fargo, North Dakota. And you have to travel to there to have your arbitration. So it can be very disruptive. Other situations have come up, and California is fighting back a little bit on arbitration where the person who signs it is not aware of the circumstances, or it's so expensive for the individual to arbitrate that the courts have ruled that it may meet a standard that they call unconscionable. Very, very tough standard to meet. And it's, in most cases, the arbitration contract, the agreement clause is upheld by the courts.
I've seen a few, so it's enough to give you hope, but nonetheless, then what? Then you're back in court because then you're contesting.
Absolutely, Mike. You go right back to court, and there you are back to starting one.
It's crazy. Okay. So, what was it? Are there like binding arbitration and non-binding arbitration clauses, or?
Well, the process, as I mentioned earlier, that if you were to go to court with a dispute over, let's say, a contract dispute between two businesses, then the court would say you have a choice to go to what the judicial non-binding arbitration. In that sense, what happens is it's run by statute, it's governed by the statutes, and says you go to before a neutral, present your evidence, and the arbitrator is usually an appointed lawyer in town with the background and experience, and they will hear the evidence and issue a ruling. And the ruling will come back and say that party A, party B prevails and takes X amount of money. Now, it's non-binding. So one of the problems is that usually neither party is happy with the outcome. But the benefit is that the parties at least get some independent feedback on the status of the case. Other cases, other situations where someone will be so incensed by not getting enough that they're now hell-bent to go all the way to trial, and they both either one can reject the ruling of the non-binding arbitrator. More and more arbitration clauses that you sign either knowingly or unknowingly in your business dealings are binding arbitration. And so the term binding arbitration is just that. You sign and you agree to all the terms, all of the procedural elements that are contained in the arbitration clause. And some of these can be several pages long. You have to read your arbitration clause before you sign it.
All right. You're given it's a little bit like we were saying before. I mean, you can have pages and pages of this stuff, and most of us are lay people. We're not lawyers,
Right.
So, anyway, what would you say if somebody had one of these? So, I mean, in many cases, like you said, I mean, it's like the telephone contract. What are you going to do?
You want the phone?
You want the phone. You're going to work with AT&T or with Sprint or whoever. They're all going to have the same thing.
Right.
So, but I guess there are some cases where you or I may be putting together an agreement.
Mm-hmm.
And we may have an attorney that's putting together this sort of using boilerplate, or maybe not even the attorney. It's one of the parties who's acting as the attorney for both, whatever. Let's just put this agreement together,
Right.
So if you see something about an arbitration clause there, what would you suggest?
Well, every buyer and seller in California that uses the standard forms under the PRDS forms or the California Association of Realtors forms have our arbitration clause, and they have a mediation agreement built into the contract. It's always there. Most realtors don't know this. They're unaware of the effect of it. Yeah, that's right. And they're not supposed to practice law. They're practicing real estate.
Right.
And their clients, of course, don't know this either. But one of the things they don't realize is that in those situations, the signing of the arbitration clause is optional. Now, there's some people that say that if one party signs the arbitration clause and the other one doesn't, then it's not a binding contract for the purchase and sale. Some counties, I understand, some counties have taken a policy of saying don't sign it. In other words, have the parties just deliberately not sign the arbitration clause as a standard practice.
Now, is this something? Do you actually put a signature there, or do you initial it, or
Initial? Yeah,
Okay.
it's large, 14-point boldface font. It has to be separately signed below the clause itself to show that you do it. So the act of affirmatively signing it is a very clear act on the part of the parties. But different counties have different policies about whether or not they will do the agreement. Obviously, the buyer who's really anxious to get that property doesn't want to rock the boat. They want to make sure their offer is good. And so they maybe say that's the risk they're going to take, and they'll sign the arbitration clause and hope for the best, knowing that if they don't, the seller may reject the agreement.
And that's a very real issue these days in Silicon Valley,
Yes.
or the Bay Area here in general, because
Right.
Especially for properties $1 million plus, it seems like we're getting the things have become so competitive just to buy a home or a property, and people are coming in with cash deals and so on. It's so hard, for an awful lot of people to try to get into the place. They really are desperate, and so they feel that, what am I going to do?
But there's a catch, but there's an escape. And one of the things in those contracts is that it says that you must go to mediation first. If you read it carefully, you'll note that mediation is not mandatory. In other words, the parties can go straight to arbitration if they wish. If they both sign it, it both goes to arbitration. If they don't sign the arbitration clause, they go straight to court. But if they, whether or not they sign the arbitration clause, the mediation clause is optional. The catch is if the parties refuse to mediate, refuse to try mediation first, they run the risk that they will be denied recovery of their attorney's fees if they go to the next step. So, in effect, most people, and again, many realtors I find, just blow over that mediation clause, or they hear somewhere that it's not mandatory, so they skip by it. But it's an opportunity to, at an early stage and for a really low cost, to go in on a confidential basis and settle the dispute early on. So again, it comes back to the fact that mediation is affordable, it's beneficial, and it's confidential, and it's the most cost-effective way to settle a dispute as opposed to any of the other means.
So the mediation clause in a real estate contract, is there a signature for that as well?
Nope.
No. So it's just a standard part of the contract.
Right.
And so what we're saying is, if you get into a dispute related to a real estate contract in California, that what you should do is say, well, before we do anything else, I think that we should, or I would like to request mediation related to this issue.
And then you go to the local real estate association or the California Association of Realtors, look at the list of their panel members. I'm on that panel. There are several others.
Yes.
And contact the one you feel is going to be able to do work, find out their availability, and schedule a mediation. It's really that simple.
Okay. Quite sure where we are in time. We'll get a cue.
We got a couple minutes here, I think.
Okay. So I went through this. I know that mediation can work different ways. So I went to one. It reminded me a little bit of when I used to be in the car business a long time ago. And so we had a closer that was going between the salesperson and the customer and the desk, and they were going back and forth. And I had something like this. Actually, we did a mediation. There we go, about 5 minutes or so. Mediation for an estate that I was involved with. Unfortunately, it was sadly my brother-in-law's estate, and so his children from a previous marriage and my sister. But the way that the mediator did it, the attorney, was basically went and talked to this group and say, okay, would you take them? And then go to the other group and would you take them? And then eventually was able to hammer something out rather than having them all sit at the same table. And he preferred to work it in that way. So do you have any comment about that? Or?
Yeah, I teach negotiating for lawyers, and it's very similar to what you would need to know to negotiate your own deal. And the preparation is largely the same. First of all, you have to go in with a realistic expectation of what's feasible. Going in and asking for the moon, is striking that bargain is a technique. It's a technique that's known as anchoring, and by going in and demanding a very high amount, does have a very positive psychological effect to get you closer to something that you may want. However, if you run the risk that if you go in and what you're demanding is not a legitimate demand, or it is so far off the top, people will just laugh at you. The tendency is people will say, well, it's not worth it even trying, and get up and walk out. So your initial demand should be high, and you should know what that is. At the other end of the spectrum, you need to know what your bottom line is. But be careful about that bottom line. You need to know what your walkaway point is. I like to call it the walkaway point. That's the point that if you don't resolve it at that point in a mediation, you then step out and resort to whatever other means that you have, whether it's litigation or some other form, arbitration perhaps, depending where you're going. So you need to know your initial demand, you need to know your walkaway point. But the other thing, and a lot of people don't think this through, is think about a concession strategy. Some things are very, very important to the other party that you could easily concede because they're low value to you, but it will help the process move forward. And you don't really know what's important to the other party until you sit down with them and start asking questions. What do you want out of this transaction? And when you find out from the other side what they want, oftentimes it's something that, gee, I didn't know. Sure, you can have that. It's no skin off my teeth to give you that. And they may have something that is of no value to them that is really important for you. And when you get into that concession strategy discussion, then you can work your way towards a resolution. Again, it takes some creativity, it takes patience, it takes persistence.
There's an analogy that I heard, and I'm sure you've heard the same thing, but there were two brothers, whatever it is. We have one orange here. What are we going to do? And I know we'll just split it in half. And so they split it in half, and one of the brothers eats the meat of the orange, and the other brother eats the peel.
That's right.
So if they had really talked about what they really wanted, then they could have each had, of course, the whole thing.
Could have had 100%. And classic example, there's a lot of exercises where we put our students through that process of they don't discover what it is the other side wants. But that's what I would say, is that mediation is a form of dispute resolution that's very affordable and very beneficial, because you can get what you might otherwise not be able to get in a courtroom. And the last thing is, it is confidential under state law, and that's a benefit in itself. But most of all, it's a way of resolving a dispute so you can move on with your life without years of litigation.
Right, and so, I mean, the real difference here for mediation is hopefully is that you're coming to an agreement between the two of you, where the other ones, you're getting a decision
Right.
that neither one of you may well like.
That's right.
So, yeah.
You're stuck with it.
Yeah. Jeff, I want to thank you so much for joining me today.
My pleasure.
Wish you a happy new year. Today is, the 17th? So anyway, hope everything goes well for you this year. See you next time on Financial Insider Weekly.